Thomas Crane. My name is Thomas Crane. I am a barrister in London. I specialise in financial regulation. I am going to describe exactly what I knew, exactly what I did, and exactly what I told myself at the time to justify it. The third thing is the most important. In March 2015, I was a senior associate at Radcliffe Chambers LLP, Magic Circle firm, corporate department. I was assigned to draft the prospectus for the initial public offering of Vertex Capital Holdings, a specialist lending company. The prospectus was 214 pages. My section was Section 4.3, Credit Risk Management Framework. I drafted Section 4.3 based on management representations and internal policy documents provided by Vertex. The management representations described how they managed risk. The internal policy documents were supposed to confirm that description. They did not match. The management representation described a 3-tier escalation system. Credit losses above certain thresholds would escalate through 3 levels of oversight. The third tier was board-level oversight. Losses above £12 million required notification to the full board within 5 business days. The internal policy document described a 2-tier system. First tier, Credit Committee. Second tier, Chief Risk Officer. No board-level escalation requirement. I raised the discrepancy with my supervising partner. His name was Michael Breslin, 23 years qualified. He spoke with Vertex management. They said the board-level oversight was informal but consistent. They said it happened in practice, even if it wasn't documented in the policy. Breslin accepted this explanation. He instructed me to draft Section 4.3 using the management representation. I drafted Section 4.3 using the management representation. Section 4.3 stated that Vertex Capital Holdings operated a 3-tier escalation framework with board-level oversight for credit losses above £12 million. That statement appeared on page 67 of the prospectus. It appeared in bold text under the heading Risk Management Governance. I wrote that text, I formatted it, I bolded it. The prospectus was published on April 14, 2015. The IPO raised £340 million from 847 investors. Institutional investors, pension funds, retail investors, through wealth managers, people who read the prospectus, people who read page 67, people who read Section 4.3 and believed it described the actual framework in place. In June 2018, Vertex Capital Holdings entered administration. Credit losses totaling £420 million had accumulated over 18 months without triggering the escalation procedures described in Section 4.3. Because the actual procedures did not require board-level escalation. Because the actual procedures were the 2-tier system documented in the internal policy document I had reviewed in March 2015. Investors lost £280 million. No legal proceedings were brought against Radcliffe Chambers. No disciplinary proceedings were brought against me or Michael Breslin. The Law Society conducted a review. The review found that I had raised the discrepancy with my supervising partner and that the supervising partner had accepted a management representation. The review found that I had fulfilled my professional obligations. I am speaking now because I have thought about Section 4.3 for 9 years. And I have concluded that thinking about something for 9 years without saying anything is its own kind of record. And that the record should be placed somewhere. I am in my chambers. It is 6:45 in the morning. I have been a barrister for 4 years. Before that, I was a senior associate for 11 years. I left Radcliffe Chambers in 2019, not because of Vertex, because I wanted to be a barrister. That is what I said at the time. On my desk there is a folder, grey leather arch folder. Inside the folder is a copy of the 2015 prospectus for Vertex Capital Holdings. Section 4.3 is highlighted in yellow. I highlighted it in 2015. The highlighting has faded slightly, but it is still visible. I have kept this prospectus for 9 years. I have moved chambers twice. The folder has moved with me both times. I am going to read section 4.3 aloud now. Not because it is interesting, because I drafted it, because I need to place on record exactly what I wrote. Section 4.3, Credit Risk Management Framework. Vertex Capital Holdings operates a comprehensive credit risk management framework designed to identify, assess, monitor, and mitigate credit risk across all lending portfolios. The framework comprises 3 tiers of oversight and escalation. First-tier oversight is conducted by the Credit Committee, which meets weekly to review all new lending proposals and all existing exposures where credit quality has deteriorated. The Credit Committee has authority to approve or reject lending proposals up to £5 million and to mandate remedial action for deteriorating exposures up to the same threshold. Second-tier oversight is conducted by the Chief Risk Officer, who reviews all Credit Committee decisions and maintains direct oversight of all exposures above £5 million. The Chief Risk Officer has authority to override Credit Committee decisions and to mandate portfolio-wide risk reduction measures where aggregate exposure exceeds risk appetite parameters defined by the Board. Third-tier oversight is conducted by the Board of Directors. Credit losses above £12 million, whether realised or anticipated, must be notified to the full Board within 5 business days. The Board reviews these notifications at the next scheduled Board meeting and has authority to mandate immediate risk reduction measures, to revise risk appetite parameters, or to engage external advisors to conduct independent credit portfolio reviews. This 3-tier framework ensures that credit risk is monitored at appropriate levels of seniority and that material credit events receive prompt board-level attention. That is what I wrote. 214 words, page 67, bold text under Risk Management Governance. I am putting the prospectus down now. I am picking up a second document. This is the internal policy document from Vertex Capital Holdings, dated February 2015. This is the document I reviewed when I was drafting Section 4.3. I am going to read the relevant section. It is shorter. Credit Risk Escalation Procedures. Exposures requiring escalation beyond Credit Committee authority shall be referred to the Chief Risk Officer. The Chief Risk Officer shall review such exposures and determine appropriate action, including but not limited to rejection of lending proposal, mandate for security enhancement, mandate for exposure reduction, or mandate for portfolio-wide review. The Chief Risk Officer shall maintain a register of escalated exposures and shall report quarterly to the Risk Committee of the Board on aggregate escalation activity and material credit trends. That is what the internal policy document said. Quarterly reporting to a Risk Committee, not immediate notification to the full Board, not within 5 business days, not for losses above £12 million. Quarterly reporting on aggregate activity. I am putting the internal policy document down beside the prospectus. They are next to each other on my desk. The prospectus is 214 pages. The policy document is 9 pages. The gap between those 2 documents is what I am placing on record. When I raised the discrepancy with Michael Breslin in March 2015, he spoke with Vertex Management. The conversation took place on a phone call. I was not on the call. Breslin returned to his office 20 minutes later. He said management had confirmed that board-level oversight happened in practice. He said it was informal but consistent. He said the board received updates on material credit issues as they arose, even if the formal policy only required quarterly reporting. He said we should draft Section 4.3 based on the management representation, because the management representation reflected the actual practice. I said, Should we ask them to update the written policy to reflect the actual practice? Breslin said, "That is not our role. Our role is to draft the prospectus based on the information provided. We have raised the discrepancy. They have explained it. We document their explanation in our file note and we proceed." I said understood. That was the end of the conversation. I drafted Section 4.3 using the management representation. I did not raise the discrepancy again. I told myself, I raised it. My partner accepted the management explanation. I am not the decision maker here. I have fulfilled my professional obligation. That is what I told myself in March 2015. I have spent 9 years testing that statement. It does not hold. I raised the discrepancy once. I accepted the partner decision. I did not raise it again. I had the option to raise it again. I could have asked for written confirmation from Vertex that board-level oversight occurred as described. I could have asked for meeting minutes showing board discussions of credit issues. I could have asked Breslin to request an updated policy document that reflected the described practice. I chose not to. The statement I told myself omits that choice. The omission is what I'm placing on record. After Vertex collapsed in 2018, I read the administrator's report. The report was 340 pages. It described the accumulation of credit losses between January 2017 and June 2018, 18 months, £420 million in losses. The losses accumulated in stages, first across small commercial property loans, then across medium-sized development finance, then across a single large loan to a property development company that had expanded too quickly. The large loan was £73 million. It went into default in March 2018. By the time the board was notified in May 2018, the anticipated loss was £58 million. The board was notified because the administrator was about to be appointed, not because the escalation procedure in Section 4.3 had been followed, because the escalation procedure in Section 4.3 did not exist. I remember reading that detail in the administrator's report. I was sitting in my office at Radcliffe Chambers. It was a Tuesday evening, July 2018. I read the sentence 3 times. The board was notified of the default on May 11, 2018, 9 weeks after the default occurred. I looked at my copy of the prospectus. Section 4.3. Credit losses above £12 million must be notified to the full board within 5 business days. 9 weeks, not 5 days. I drafted the 5 days. I wrote that number, I checked it, I formatted it. I submitted it for publication. I closed the administrator's report. I closed the prospectus. I went home. I did not speak to Michael Breslin about it. I did not speak to anyone about it. I want to be precise about what I am saying. I am not saying I committed fraud. Section 4.3 was based on a management representation. The management representation was provided in good faith by Vertex. It described what they believed to be their practice. I am not saying I breached any professional duty. I raised the discrepancy. My supervising partner accepted the management explanation. The Law Society review found that I had fulfilled my obligations. I am saying something narrower. I am saying I knew there was a gap between the prospectus and the policy document. I raised it once. I accepted the response. I did not raise it again. And I told myself that raising it once was sufficient. That is what I'm placing on record, not what I did wrong legally, what I did that I think about. There is a fact about legal practice that they do not teach you in law school. When you raise an issue once and your supervising partner accepts a client's explanation, you have created a record that protects you. The record shows you identified the issue. The record shows you escalated it. If something goes wrong later, the record shows you did your job. The fact they do not teach you is that the record protects you whether or not the client's explanation was sufficient. The record protects you whether or not you believed the explanation. The record protects you whether or not you raised the issue a second time. In March 2015, I understood that fact. I raised the issue. I created the record. I stopped. 847 investors read Section 4.3. They believed the three-tier escalation framework existed because I wrote that it existed. They invested £340 million based on that belief. They lost £280 million when the framework they believed in was not there. I do not know their names. I know the aggregate number, 847. I know the aggregate loss, 280 million. I know that somewhere in those numbers there are people who needed that money for something: retirement, children's education, medical care, a life they had planned. I know that because I wrote Section 4.3, their plan was based on information that did not match the policy document I had reviewed. I am squaring the prospectus and the policy document now. I am putting them back in the grey folder. I am closing the folder. I do this every time I take them out. I have taken them out approximately 60 times in 9 years. Every time I close the folder, I think, this is the last time. Every time I open Chambers in the morning, I think, not yet. It is 7:32 now. I need to be in court at 9:15. I am appearing in a judicial review. Financial regulation matter. My client is challenging a regulatory decision. I need to leave Chambers at 8:40. I am going to make tea. I am going to review my submissions. I am going to walk to the Royal Courts of Justice. I am going to stand up and argue that the regulator's decision was unreasonable. This is what I do now. I argue about what regulators should have done, what firms should have disclosed, what directors should have known. I do it well. I have a good reputation. Solicitors instruct me because I understand financial regulation, and I prepare thoroughly and I identify the weaknesses in the other side's case. I prepare thoroughly because of March 2015. I identify weaknesses because I know what a weakness looks like when you are the person who has seen it and has raised it once and has not raised it again. Before I leave Chambers, I'm going to do something else. I'm going to open a different file. Blue lever arch folder. Current matter. I am advising a client on the prospectus for a planned IPO. The client is a specialist lending company, smaller than Vertex. The IPO will raise approximately £80 million. The prospectus has a Section 4.2, Credit Risk Management Framework. I drafted Section 4.2 in October. I reviewed it in November. I reviewed it again in December. I reviewed it a third time 2 weeks ago. The management representations and the internal policy documents match. 3-tier escalation framework. Board-level notification within 5 business days for losses above £8 million. The policy document states it. The management representations state it. They match. I checked 3 times. I am going to check a 4th time this afternoon. I am checking a 4th time because of what I did not do in 2015. I raised the discrepancy once in 2015. I am going to raise any discrepancy in 2024 as many times as it takes. Until the client provides written confirmation, until the policy document is updated, until I am satisfied that what I write in the prospectus matches what will actually happen when a loan goes bad. That is not absolution. That is the job I should have been doing in 2015. I am opening my diary now. Today is February 6th, 2024. I have the judicial review at 9:15. I have a conference with solicitors at 2 o'clock. At 4 o'clock, I have an entry that says, Section 4.2, check again. I put that in my diary 3 days ago. I put it in my diary because I trust documents more than I trust myself. I do not trust that I will remember to check a 4th time unless I write it down. I do not trust that I will raise an issue a second time unless I create an obligation to raise it. I do not trust the version of myself that raised the vertex discrepancy once and then stopped. So I write it down. Section 4.2, check again, 4 o'clock. I will check the management representations against the policy document. If they still match, I will sign off on Section 4.2. If they do not match, I will raise it again. And if the client provides an explanation, I will request written confirmation. And if the written confirmation is insufficient, I will raise it again. I will raise it until the prospectus matches the policy, or until the policy matches the prospectus, or until someone tells me I am no longer instructed. I do not know if that is the right approach. I know it is a different approach than the one I took in March 2015. It is 7:41 now. I need to leave for court in 59 minutes. I am closing the diary, I am closing the blue folder, I am putting the grey folder back on the shelf where I keep it. I am going to make tea, I am going to review my submissions, I am going to walk to court, I am going to argue that a regulator's decision was unreasonable. I am going to return to chambers at 3:30. I am going to open the blue folder. I am going to check Section 4.2 a fourth time. I have been asked why I am speaking now. The answer is that I have carried the grey folder for 9 years, and I do not want to carry it for another 9. Not because speaking will remove it, because I think speaking creates a different kind of record, not the record that protected me in 2015, a record that places on the register exactly what I knew, exactly what I did, and exactly what I told myself. The third thing is the most important. Because the third thing is what lets you raise an issue once and stop. The third thing is what lets you write the 5 business days into Section 4.3 when you have reviewed the policy document that does not require 5 business days. The third thing is what you tell yourself so that you can close the file and move to the next matter and finish the day and go home. I told myself I raised it, my partner accepted it, I fulfilled my obligation. What I did not tell myself, I chose to stop after raising it once. That choice is what I am placing on record. It is 7:48. I need to leave in 52 minutes. The grey folder is on the shelf. The blue folder is on my desk. Section 4.2. Check again. 4 o'clock. I am going to make tea now. I am going to go to court. I am going to come back. I am going to check a 4th time. This is what I do now. I check again. My junior clerk arrives at 8 o'clock. Her name is Sophie. She is 24 years old. This is her 2nd year in chambers. She brings the brief for the 9:15 hearing. She asks if I need anything else. I say no. She sees the blue folder on my desk. She says, "Is that the Drake IPO?" I say yes. She says, "I thought you signed off on Section 4.2. I look at her. I say, "I'm checking it again." She nods. She leaves. I hear her footsteps down the corridor. I hear the printer start in the shared office. What I knew, Sophie drafted Section 4.2. She worked on it for 11 hours. She sent it to me at 2200 hours on the Thursday. I approved it at 08:30 on the Friday. The Drake IPO went live at 1600 hours that same day. What I did, I approved Section 4.2 without checking it against the updated compliance framework. The framework had been amended on the Wednesday, 2 days before Sophie sent me the draft. I received the amendment notification at 14:20. I read the subject line. I marked it as read. I did not open it. What I told myself, the compliance team will catch it. There are 3 levels of review after mine. This was true. There were 3 levels of review after mine. What I did not tell myself, I am the only lawyer who reviews Section 4.2 for legal accuracy. The 3 levels after mine review for formatting, consistency, and final sign-off. They assume the legal review has been completed. It is 7:53. I have 47 minutes. The Drake IPO raised £470 million. Section 4.2 concerned disclosure requirements for material contingent liabilities. The updated compliance framework changed the threshold from £5 million to £2 million. Drake Technologies had a contingent liability of £3.8 million relating to a patent dispute in Germany. Under the old framework, disclosure was discretionary. Under the new framework, disclosure was mandatory. Section 4.2 did not disclose it. I approved Section 4.2. The Drake IPO went live with Section 4.2 as approved. What I knew at the time, I approved it. Nothing. What I knew 3 weeks later, everything. The compliance team sent the query on the Monday. Day 19 after the IPO, they had been conducting the routine post-completion audit. They found the notification email from the Wednesday. They checked Section 4.2. They saw the German patent dispute was not disclosed. They sent the query to my senior partner. My senior partner sent it to me at 1100 hours with the subject line, "Call me immediately." I called him at 11:03. He asked me if I had read the updated framework before approving Section 4.2. I said, "I do not recall." He said, "Thomas, this is important. Did you read it or not?" I said, "I marked it as read." He said, "That is not what I asked you." I said, "I did not read it." He was silent for 47 seconds. I counted. Then he said, "All right, thank you for your honesty. We will need to meet this afternoon. 1400 hours. Conference room 2. He ended the call. What I did, I opened the notification email. I read the updated compliance framework. I read Section 4.2. I checked the Drake disclosure schedule. I confirmed what they had found. Then I sat at my desk for 90 minutes without moving. What I told myself, it was an honest mistake. I was under pressure. I had 4 other matters that week. This was true. I did have 4 other matters that week. What I did not tell myself, I chose not to open the email. I saw the subject line, Material Update Compliance Framework, IPO Disclosures, effective immediately. I saw it. I marked it as read. I chose to treat the subject line as sufficient. The meeting at 1400 hours lasted 4 hours and 12 minutes. My senior partner, the head of compliance, the managing clerk, a solicitor from our professional indemnity insurers. They asked me to describe my review process for Section 4.2. I described it. They asked me if I had seen the notification email. I said yes. They asked me if I had opened it. I said no. The solicitor from the insurers asked, "Why not?" I said, "I assumed it was procedural." She said, "The subject line says Material Update, effective immediately." I said, "I made an error in judgment." She said, "Mr. Crane, we need to understand your state of mind. Were you aware at the time that you were choosing not to open it? Or did you simply forget it existed? This is the question. This is the question I have been asking myself for 9 years." I said, "I was aware I was choosing not to open it at that moment. I told myself I would open it later. I did not open it later. I forgot I had told myself I would open it later." She wrote this down. She said, "Thank you for your candor." What happened next? The firm reported the matter to the Financial Conduct Authority on day 23. The FCA opened an investigation on day 31. Drake Technologies received a formal notice of the disclosure deficiency on day 42. They issued a supplementary disclosure statement on day 49. The share price fell 16% in one day. 7 shareholders initiated legal proceedings on day 68. They alleged material non-disclosure. They sought damages of £43 million. The firm's insurers paid £28 million in settlement on day 411. I was not personally liable. The firm carried professional indemnity cover. What I told myself, I was not personally liable. The system worked. The error was caught. The shareholders were compensated. I made a mistake. I learned from it. I moved forward. What I did not tell myself, Sophie checked with me 3 times during her 11 hours of drafting Section 4.2. She sent me queries at 1600 hours, 1930 hours, and 2100 hours. In her 2100 hours query, she asked, should I double-check the German patent situation against current disclosure thresholds? I replied at 2117 hours. I said, threshold is 5 million. Patent dispute is 3.8. No disclosure required. Good work today, Sophie. I wrote that reply 79 hours after the notification email that changed the threshold to £2 million. Sophie resigned from Chambers on day 97. She sent her resignation letter to the managing clerk. She did not send me a copy. I received a copy from the managing clerk at 1700 hours. The letter was 6 lines long. It said she had accepted a position in a different area of law. It thanked Chambers for the opportunity. It gave 4 weeks' notice. I went to her office at 1720. I knocked. She said, come in. I closed the door. I said, Sophie, I received your resignation letter. She said, yes. I said, I want you to know that the Section 4.2 matter was my error, not yours. You followed my instruction. She looked at me. She said, I know that, Mr. Crane. I said, is that why you are leaving? She said, no. I said, can I ask why you are leaving? She said, I do not think I am suited to this work. I said, you are an excellent junior. You have a strong future here. She said, thank you. I have made my decision. I stood there for 19 seconds. Then I said, I am sorry this happened. She said, so am I. I left her office. I went back to mine. I sat at my desk. I looked at the blue folder. Then I opened my email. I searched for her name. I read every message we had exchanged. 247 messages over 2 years. In 41 of those messages, Sophie asked me a question that began with the words, should I check? Should I check the filing deadline? Should I check the disclosure schedule? Should I check the witness statement? In 41 messages, I replied. In 38 messages, I said, yes, please check. In 3 messages, I said, no need, I have confirmed it. The Section 4.2 query was one of the 3. It is 7:58. I have 42 minutes. Sophie left Chambers 9 years ago. I do not know where she works now. I do not know if she continued in law. What I told myself then, she made her own choice. She could have stayed. The firm supported her. No one held her responsible. What I tell myself now, I taught her something. I taught her that checking is not enough. I taught her that following instructions from someone senior is not enough. I taught her that the system fails. And I taught her that when it fails, the person with the least power is the one who cannot live with it. This is what I am placing on record. Not the error, not the settlement, not the disclosure. The teaching. The thing I taught someone 22 years younger than me about what this profession asks you to become. The grey folder is on the shelf. The blue folder is on my desk. I am checking again. I will always check again now. But checking again does not undo the teaching. It is 800 hours. I have 40 minutes.